The U.S. Supreme Court now considering whether a Colorado web designer can refuse business to gay couples.
The ruling will apply to artists and designers all over the country, including North Carolina. But is it a case of free speech or discrimination? I turn to a constitutional expert to break it all down. Colorado website designer Lori Smith says she will work with any client. That is, as long as their message does not conflict with her religious belief that marriage should only be between a man and a woman. That puts her at odds with Colorado's anti-discrimination law, which Smith claims violates the free speech clause of the First Amendment. UNC professor of constitutional law, Mary Rose Papandrea.
She's claiming that the fact that she would create a website using words, symbols, photos, that's the speech that she's objecting to, that website that would express a message celebrating a same-sex union. So for her, it's not sufficient just to have a disclaimer on her website that she opposes same-sex weddings. She doesn't want to have anything at all to do with same-sex weddings.
Smith spoke outside the Supreme Court.
For every artist like me who wants the right to decide without government threats or intimidation, free speech is worthy of protecting.
But defending Colorado law, the state's attorney general says it's about equal treatment.
They can say on the website, we believe in marriage as celebrated in the Bible. They can't decide that because of your sexual orientation or your religion, you can't purchase the product. That's what this case is about.
However, based on the justice's statements and questions, the conservative majority did appear to lean one way.
It did seem, reading the tea leaves at the oral argument yesterday, that there will be a majority of the justices who will say that this website designer is engaged in speech when she creates websites for weddings, that forcing her to create websites for same-sex marriages would violate the First Amendment and compel her to speak against her viewpoint.
Papandrea does also believe it's important for people to understand that however the court rules, its implications won't affect most businesses.
The case is not about whether any and all merchants can avoid dealing with members of the LGBT community as a whole, even whether merchants can avoid providing services for a same-sex wedding. It is limited to merchants who are engaged in speech as part of the services that they provide.
And, you know, in other words, it doesn't have to be just about a merchant dealing with a, gay or lesbian couple or client. It can be, across the board for anyone who they feel they have to produce something artistically or creatively that they don't agree with.
It'll be interesting to see
it will be,
how
and
it plays out.
Probably won't know till June.
All right, Russ, thanks.
You bet.